People in Illinois are worried a new law could become a gateway for the purge to really happen. It has taken root on social media and is spreading like wildfire.
Well, it's here, the Safety Act. Now, there's plenty of people on social media telling us that this is a great idea or it's a not so great idea, and I'm not going there. This is just an overview of what happens now. So this video, it's gonna cover three things. One, how it works for new defendants. Two, what happens to those who are already in jail under the old bail bond system. And three, how the appeals process works for pretrial detention. And I'll start off by saying this video, well, at least part of it is gonna be obsolete within a few months, because when you have such a massive overhaul, historically, a lot of people are gonna appeal, and every day the appellate courts release decisions that reshape how the law is interpreted. So it's gonna happen, just roll with it. But if you wanna stay on top of all these changes, and there's gonna be changes, well, you know what to do, because I'll be covering those as they're released. With that, let me disappoint a few by reminding everybody this channel's a hobby. I can only do it when time permits. And since many of the Safety Act's rules have, well, exceptions within exceptions, especially when the charges say domestic violence related, well, this video is going to be more than a broad overview, but due to my time constraints, a little bit less than a CLE, if you get what I'm saying. So with that said, who's going to jail and who's not? Well, it's like a choose your own adventure book where some charges go through one particular pretrial system and others through another. The small crimes, if you will, well, they're formally reduced to a citation system similar to like a traffic ticket. And here's my best visualization. Anything that's a non-felony or below a Class A, most of the time it's just going to be a citation. Show up to court on a certain date. They can still arrest you, but notwithstanding certain DV-related charges, the most likely outcome is for the court to impose additional conditions on the defendant before releasing them. As for the other charges, though, well, it'll mostly be up to the prosecution, because now, in order to jail someone pending trial, in most cases, the prosecution must file a petition. It is discretionary, but in some circumstances, such as a prior OP violation, the state's attorney is compelled to file one. So most of these are going to be discretionary by the prosecutor, but a few are going to be mandatory. On the day the petition for pretrial detention is presented, the court will decide whether to hold the defendant or not. And the statute allows short continuances depending on the charge. And these hearings, well, you know, for reasons that are self-evident, will likely proceed via proffer, but you can call witnesses if needed. Now the state, well, they carry the burden, and the standard is clear and convincing evidence. For those new to law, it's not that their argument is better, but it's like way, way better. It is clear, it is convincing, and it must go through this process. Step one, is the detainable offense one that allows detention? That one's pretty self-explanatory. Two, does the defendant pose a real and present threat to the physical safety, key word, to someone, someone's, or the community? Or if you can't prove two, then the alternative, will the defendant skip town if you let him go? For example, they missed a ton of prior appearances for past charges and missed them because, well, they felt like it. So either danger or skipping town must be shown, followed by this third criteria, that jailing the person while they await trial is the only way to be mostly sure. So what are the type of crimes that a state's attorney can file a detention request? Well, they fall into a lot of categories, and this is a really watered down list. It includes like felonies where upon conviction, some minimal amount of prison time is required for that defendant. It includes just about any forcible felony, with the exception of burglary, and lots and lots of family law related crimes are also included, like stalking, violating order of protection, domestic battery, and certain sex offenses excluding prostitution related crimes. Now you may be wondering, what makes somebody dangerous? Well, the court has these factors under section 6.1G, which they can consider. I just wanted to point out, if you have a high conflict family law case, it is now on like Donkey Kong. So if you feel this is something that you may need to appeal, you may want to argue these factors line by line, because, well, a good appeal can't fix a bad trial. And I'm going to go over the appeals process here in just a moment. But before I do that, let me cover what else a judge has to do in order to hold somebody. If the judge says this person's too risky to release, they must make written findings explaining why they did what they did. And every court appearance thereafter, they have to review those findings to make sure that they still make sense. So how long can someone be held awaiting trial? Well, the answer is 90 days. 90 is the max someone can be detained without trial. After that, they must be released pending trial. It's kind of similar to our speedy trial system, except if it's violated, the charge isn't dismissed. They just get to go home and wait for their trial to start. And keep in mind, like the speedy trial requirement, those 90 days, well, they can be told a lot of ways, and the most common one is by agreed continuance. So don't get too excited. Not all days will be counted towards that 90-day limitation. Now for the part a lot of you may be curious about. What happens to all the people under the old rules? Well, for those out on bond, they stay out, but it's now called pretrial release. Pretty simple. But the state can, if they want to, file a motion to have them detained. So those that are bonded out are not automatically home free. Conversely, those in jail awaiting trial, well, they can file a motion for pretrial release. Now keep in mind, they have to file it, and there are time limits to file such a motion. And as you can see here, depending on the charge, the deadline to file that motion ranges between 7 to 90 days. So keep an eye on that calendar once the stay is lifted next month. Now we get to my favorite part, appeals. Yes, Virginia, a court's decision regarding pretrial release is immediately appealable by either the state or the defendant. And these appeals are on like a super duper accelerated timeline. And the trial court retains jurisdiction to move forward with the case in the interim. There's one thing I want to stress to practitioners with tears in my eyes. The deadline to file a notice of appeal regarding pretrial detention is 14 days. Let me repeat that. 14 days, not 30. Tattoo it on your arm, please. As I've said, this is a new statute. Expect changes within the next few months. If you don't feel like waiting outside the appellate courthouse for those changes to kind of come out the building, you can stalk this channel because I will be covering them when new firmware updates are announced. Anyways, that's all I have. I hope you enjoyed this kind of special broadcast, and we'll be back again in a few weeks with new case law updates. Until then, as always, thanks for watching. I couldn't find the other one.
He's trying. Hold on, let me go. Hello? We're at the scene for
and the shame was on the other side. Oh, we can beat them forever and ever. We can be